Marquez, sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 17th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant has been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining
Same
witness?
complainant.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand? So it looks like a protective order has been issued. I would get to know it, because if you violate this protective order, the state can and will file a violation protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay.
Sarmiento.
Sarmiento,
Sarmiento.
Sarmiento Court.
S-A-R-A?
Yes.
Sarminto. Sarmiento.
Okay, all right. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 13th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed without a front license plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door, and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community. It's not going to go well for you. Do you understand?
Yes.
And we'll have you sign a resolutoria. We will have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
Paredes, You were charged with tampering with a government record with intent to make it genuine? Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with a government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate, and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck, that he receives a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says he was saying.
Well, right. But I mean,
Right.
Marcos, I see what you're saying because he's charged with tampering, right? To tamper, you must, I know, let's pull the code.
Right.
Because I mean, do you have to make a willing,
But you negligently or recklessly.
an alteration, so to speak, you know? Let's see. 3710. Bless you. No, that's, oh.
Knowingly makes a false entry in the false alteration of a government record.
A person commits, if he knowingly makes a false entry in or false alteration of a government record, makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor,
I think that is what they're probably relying on in this case.
if I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So,
Well, he doesn't know it was intended lawfully, even from.
Well, hold on. That's your burden,
yes,
right?
Judge, and in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, from the state authority, right? They give you the license plate, but here,
They give you the paper plate and you assume that they're going to do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
if this had been like maybe a month or two that he'd purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long.
and
it's-
this car purchase,
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists a date of loss as May 29th, 2020. So I don't know if that's when the defendant obtained it or that's just. when
no,
it
that's
was
just
salvaged.
when it was salvaged at
Yeah,
that
so
time.
that's
So
the
at that
only-
point, you can't even drive the car because it's salvaged, right?
Right, and
It's a
that's
salvage title,
the
but
date that the officer provides. So, so with the information
you
we
have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025 and lists the vehicle as a 2007 Chevrolet and it doesn't
Is
list.
this, it should say like a date of purchase, right? Why don't we do this? Look,
So it says it expired February 5th, and this happened in January 16th. And I just asked him when he bought it. He said it was about a month and a half ago. And I said, how many?
let's do this. Show me. Let me give you more time. Let me just do a little bit more diligence.
Okay.
All right. We'll come back, but let me burn through all this because I didn't think it was going to take this much time, but we'll revisit it. Okay.
Yes, yes.
Don't worry.
So these are really, really old cases, huh?
Your super old judge, she had one attorney, I think it was during the pandemic that we subbed in on, and then the other case as well, Your Honor. And it was a mix of a lot of things financially and on why he was kind of MIA.
Did you represent him before?
We were on the case, we just never got off. We were on the assault case.
Are you wanting to stay on or do you want to get off?
We're gonna stay on, Judge.
Okay.
You guess in a way rehired.
So, Mr. Montalongo, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already.
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay.
Okay, go for it.
Yes, Judge. On February 28, 2023, the officer responded to a terroristic threat, and the complainant stated she is the sister of the defendant, and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, "I hope you take a punch to the fucking face. I'ma break your fucking face with my fist, bitch. I want to hear your bones break." The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they are missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to
Because I'm
happen, or
going
some
to.
future event.
I mean, I'm going to.
I'm going to, it can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent. Therefore, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, "I'ma break your face with my fist." So that would go towards, I doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, the I'm going to, and just the overall tone of the
Mhm.
message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a plea bargain from the state or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. So I'm good from there.
Understood, Judge. Thank you.
Speak up here, as well.
We're not